Parliament has been granted 6 months to finalise the Electoral Amendment Act. It's an extension granted by the Constitutional Court this week. The Act will allow independent candidates to take on political parties at national and provincial levels of elections. For more on this, we're joined by Executive Director at Casac, Lawson Naidoo. Lawson, always good to have you on the programme. So a 6-month extension given to Parliament to finalise this. Do you have any faith at all that they can get it done?
Good afternoon. Thank you very much. Look, I think the main issue is what can be done in the time that the additional time that Parliament has now been granted. They've already had 2 years from the time of the judgment of the Constitutional Court in the New Nation Movement case in June of 2020 to fix the electoral system. And Parliament and the Minister of Home Affairs have failed to do that. And in fact, the Constitutional Court in its judgment that was handed down earlier this week commented on the dilatory attitude of both the Minister and of Parliament in taking adequate steps to try and meet the deadline. Now, what's going to happen now is that we've got, before Parliament, before the Portfolio Committee on Home Affairs, a highly flawed piece of draft legislation that simply seeks to add independent candidates to the current list system, really requiring them to contest provincial elections according to existing provincial boundaries. And that obviously puts independent candidates at a disadvantage. There are numerous flaws with the current role. And there's also been inadequate public consultation on the kind of new electoral system that we need in South Africa. And I'm not sure that an additional 6 months is going to be sufficient for broader public consultation to happen and for there to be meaningful electoral reform that addresses the needs and concerns of our democracy.
I'd like to expand on those flaws that you've mentioned, because there have been some other critics who say the very premise of the Act is what's not going to withstand sort of constitutional scrutiny.
Indeed, and I think there's been two things. One, there's been a fixation on simply complying with the judgment of the court in the New Nation Movement case, which was a narrow judgment, merely focusing on the right of independent candidates to contest national and provincial elections. But what that judgment does is to open up the opportunity for meaningful electoral debate and reform. Opportunities that we have spurned in the past, in the early 2000s with the Finalise report, and again more recently. So this is an opportunity to have that proper debate about the kind of electoral system that we need, and simply adding independent candidates to the current party list system does not provide for meaningful change. So some of the flaws are that, for example, in the bill at the moment, independent candidates would need to earn far more votes than political parties in order to secure a seat in Parliament or provincial legislature. Any votes that they get beyond what is required to secure a seat would be wasted. There are no clear mechanisms as to how vacancies arising out of the death or the vacancy created by an independent candidate would be filled. There are a huge range of issues also in relation to the level of the deposit that an independent candidate would be required to provide, as well as the number of signatures they would be required to get in order to get themselves onto the ballot paper. So there are a whole range of flaws in the bill, and I don't think that it's going to be able to remedy or fix them.
Right.
Parliament needs to take a more holistic look at a constituency system, which would be a far better model to accommodate independent candidates.
And I suppose what you're saying, based on that, then, I don't imagine that you would be surprised, Lawson, to hear that just yesterday members of the Home Affairs Portfolio Committee were debating whether or not independents should be allowed to run in more than one province, for example. And as you were saying, given that this is a race against time, where are the legal advisors to Parliament, and how much of a role do they play as the lawmakers debate those technicalities?
Well, look, I think what Parliament is trying to do is to fit a square plug into a round hole. Accommodating independent candidates within this system is almost impossible. And the model that is being proposed at the moment by the Minister of Home Affairs is an electoral model that doesn't exist anywhere else in the world. And if we scan the globe, there are many, many different electoral systems that we could adapt and use, but we've chosen not to go that route. And I think the policy decision that's been taken, and therefore Parliament's legal advisors, as well as the state law advisors, have been forced into trying to do the best with a very, very poor policy framework to work within.
Do we need an all-new bill altogether?
I think we we need to start with a proper public participation process to put all of the options on the table. You'll recall that last year the Minister, Motsoaledi, put in place a ministerial advisory committee. And the report of the majority of those members of that advisory committee have been ignored because they recommended a constituency-based model, and rather the minister and government have opted to go with the minority view. And so I think we need to restart the public debate and put all the options on the table so that the public, at the end of the day, are the ones that get to choose the electoral system. It's inadequate for political parties who are inherently conflicted to choose the electoral system that will benefit them at the expense both of independent candidates, but more importantly, of the voters.
Do you think they're actively trying to avoid a situation where there is that more competitive space where independents are able to run and perhaps even unseat parties in government?
Yeah, I mean, whether that will happen or not, I mean, I think the dilatory attitude displayed by the minister, this judgment, as I say, was in June 2020. The minister only tabled the draft bill that is currently before Parliament in January of this year, 6 months before the June deadline. And it really shows that government has not taken this process seriously. They've ignored, as I said, the majority report of the Ministerial Advisory Committee. And there's been no attempt whatsoever to engage the public on broader or different electoral models. In fact, the public hearings that were held earlier this year, most of the proposals that came to Parliament suggested a different electoral model, and yet Parliament has simply ignored all of those voices.
Lawson Naidoo, good to speak to you. Thank you very much.